Hello, a very warm welcome to today's webinar. My name is Thomas Moschig and I'm the Commercial Attaché at Advantage Austria here in Mexico. Today it's my pleasure to guide you through this session. And I'm delighted to welcome you all to our USMCA webinar series. Today we launch our third episode featuring Mark Tallo, our USMCA expert of today's session, live from Washington, DC. Many of you have already participated in the first two USMCA webinar sessions, and that was before the agreement actually was put into place. Back then, like today, we tried to analyze the agreement and its output for the Austrian economy from different perspectives. We tried to make complex material more understandable practically, alongside with our trusted experts, and we would also like to give you the opportunity to raise concerns and ask questions. For those of you who haven't participated in the last webinars, I would quickly like to emphasize that this webinar is a joint production of our three North American offices, namely Advantage Austria, Mexico, New York, and Toronto. So here goes my shout out to all my colleagues from these offices. Many, many thanks to you guys who have been so kind to support me with the preparations. So before we kick off, I wanted to mention that this webinar is supported by Go International. You saw you saw the logo on the bottom right corner of the slide. Go International is an initiative with the Federal Ministry of Digital and Economic Affairs, as well as the Austrian Federal Chamber. The aim of this fund is to support Austrian companies in their expansion abroad. Go International is currently in its 7th edition and is a co-financing tool for domestic companies seeking growth internationally. I invite all of my Austrian fellow listeners today to visit Go-International AT for further information in case of interest. But now let's start with the technical details, and these are the following. I'm sure many of you are already used to online meetings, and you probably know that these kind of webinars are usually recorded. This is also the case in today's session. The video, as well as the presentation and the contact details of all the parties involved, will be sent out to all the registered parties within the upcoming days. And lastly, after my introduction, we will hear our guest speaker who will be addressing all your questions at the end of the presentation. For those of you who aren't familiar with the platform GoToWebinar, you should find the Go-To navigation window on the right side of your screen. And there you will find, among others, the chat window. And I would ask you to please post your questions into this chat window. And at the end of the session, we will collect all your comments and questions and forward them to our expert at the end, at the final stage of this webinar. So let's get started. USMCA, where did it all begin? A quick recap. The North American Free Trade Agreement was an agreement signed by Canada, Mexico, and the United States. As you all know, that created a trilateral trade bloc in North America. The agreement came into force on January 1st, 1994, and replaced the bilateral 1988 Canada-United States Free Trade Agreement. Back then, NAFTA formed the largest trade bloc in the world by GDP and was also one of the most innovative commercial agreements in the 20th century. Then came July 1st, 2020, and led us into a new era, so to speak. A new agreement between the three countries, US, Canada, and Mexico, commonly known as USMCA, replaced NAFTA. Many newspapers titled back then, North America concludes a superlative trade pact. And indeed, that was the case since the three neighbors trade 1.2 trillion US dollars in goods each year. The agreement affects nearly 500 million people, and the economic output of the region is about 23 trillion US dollars a year. All three countries involved saw themselves as winners of the updated treaty, but also the European industry, especially automakers and their Austrian suppliers, stand to benefit if they comply with the now stricter requirements. Yes, the agreement is sometimes characterized as NAFTA 2.0, since it largely maintains or updates many provisions from its predecessor. On this slide, you can see areas and chapters which underwent significant changes since USMCA is in force. Typically, the automotive industry and the steel industry is of high interest for the Austrian export industry or the Austrian export community, as well as for Austrian subsidiaries in these three mentioned countries. But many other chapters underwent quite significant moderation as well. Labor requirements, for example, were redefined. Environmental perspectives also got more attention. And also already disputed topics like intellectual property and e-commerce chapters were defined more in detail, and the list continues. So the question is, what changed and what's there to consider for Austrian enterprises active in the North American market? We will now focus on exactly these questions in the upcoming 20 to 30 minutes. Our guest speaker will give you an overview on the provisions of the agreement, which cover a wide range, including manufacturing products, labor conditions, digital trade, among others. And yeah, speaking of today's protagonist, I would like to present you our speaker of today. Let me jump right back here. We're delighted to have Mark Tallo with here today. Hello, Mark. Mark is a member of the Import-Export Practice Group of Sandler, Travis and Rosenberg, PA, resident in Washington, D.C. office. His practice areas include customs, import and export compliance, as well as international anti-corruption measures, among others. And he also advises clients on governmental procurement issues. Mark holds a GD from George Washington University Law School and a BA in Political Science from Houghton College. And additionally to all that said, Mark is our trusted lawyer of Advantage Austria, and a reliable partner for all our offices in North America, and especially in close contact with our Advantage Austria colleagues in New York. So Mark, it's good to have you here. Please guide us through today's topics, USMCA, and an overview and its practical implications for Austrian enterprises. Once again, it's good to have you here, and the floor is yours.
Thomas, thank you so much for that great introduction and the invitation to speak, both working with you and your colleagues in Mexico and the United States and Canada has been great over the past years since USMCA went into force. So we're going to talk a little bit about the USMCA agreement. It's a very complex and broad-ranging agreement, as Thomas said. You know, it is in some ways NAFTA 2.0, and in other ways a very different agreement. So just to get this out of the way, this content and presentation is for informational purposes only. It shouldn't be construed as legal advice. If you do have specific issues, again, because USMCA is very complex, I'd recommend consulting trade lawyer or trade consultant to help you through those problems. As Thomas mentioned a little bit about me, I'm an attorney in the Washington, D.C. office of Sandler, Travis and Rosenberg. I focus my practice mainly on import compliance issues into the U.S. And in particular, focusing on ways companies can minimize the duty paid upon import into the U.S. And many of those ways involves the use of preference programs, free trade agreements, including the USMCA, which we'll talk about today. Some of the topics we'll walk through is kind of the importance of USMCA, the transition from NAFTA to the USMCA, reviews some of the overview and general provisions of the agreement. We'll walk through some rule of origin examples so you can get a sense of the way some may have changed from NAFTA to USMCA, and spend a good bit of time focusing on auto-specific rules and guidance related to those rules, as that is one of the principal changes from NAFTA to USMCA. And as Thomas mentioned, we'll have time for questions at the end. So a little bit about USMCA's importance. So USMCA, as Thomas indicated, continued the integration of the North American economies that was created by its predecessor, NAFTA, back in the early 90s. But NAFTA was created and agreed to in a really different time with different economic and political forces than are in place today. And so USMCA was attempting to sort of update those to today's both economic and political issues. And the first place that we notice that is with the name of the agreement. So instead of the North American Free Trade Agreement, this drops North American, the regional focus, and free trade altogether, and just as a list of countries with agreement after the name. And so, this resulted in an agreement which has 3 different names depending on the country in which you are operating. And so the Canada-US Mexico agreement is the Canadian perspective. Other countries list the countries in different ways. So just something to keep in mind. If you see these other acronyms or names, it's all the same agreement, but for simplicity's sake, I'll be referring to it as USMCA today. The other thing, as Thomas mentioned, kind of the global significance of the North American integrated economic region. So together, the North American countries in USMCA represent about 30% of global GDP, which is almost double that of the EU countries and China. So while it is a little less ambitious than maybe the TPP was, it certainly is an important global economic region for North America. So we'll turn now to a little bit about an overview of some of the USMCA provisions and how they may have changed or are different from NAFTA. So as I mentioned, free trade was dropped from the name of the agreement. Free trade is kind of no longer in favor in sort of Western economic circles. So we no longer see that, but anyone who's involved in trade agreements or preference programs know they're really not altogether free. There are requirements and costs associated with compliance and the related obligations in order to obtain that duty-free treatment. But this slide just is a graphic representation of kind of those layered approaches to free trade. And so in order to get that duty-free status or duty-free entry for your goods, you need to, at the very basic level, meet the product-specific rule of origin. And we'll walk through a few of those in a minute, but it's based on either a tariff shift or a regional value content, or a combination of the two, in order to determine whether your product meets the product-specific rule of origin. But added on to that can be additional product-specific requirements, and we see this in particular with automotive goods, as well as some steel or aluminum products. There is an additional hurdle that you have to meet. And then even layered on top of this, either at the entity or countrywide level, there are additional requirements that USMCA imposes with regard to labor practices, environmental practices, anti-corruption, and a whole host of other things, intellectual property. All of those are layered on top of the basic kind of rule of origin level requirements. So again, the USMCA was kind of a general update to NAFTA. It was intended to modernize the agreement, to bring it into the 21st century. And in the intervening time between NAFTA and USMCA, Mexico, Canada, and the United States were negotiating parties to the Trans-Pacific Partnership, or TPP, which included a lot of modernized provisions that some of which found their way into USMCA. And the other thing for USMCA was the ability to fix some issues related to NAFTA that were perceived as not working. And so one of the major ones involved labor practices and wage growth in Mexico. Despite the economic growth as a result of NAFTA that Mexico saw, a lot of the labor and wage growth wasn't seen in Mexico, even though the economy overall was growing and many manufacturers were moving production to Mexico. The labor practices and wage growth were perceived, in particular in the US, and in particular by the Democrats in Congress, as not being sufficient. And so included in USMCA were provisions, as we'll see in autos, for a specific labor value content, but also practices related to labor provisions and labor laws, as well as wage growth was included in the agreement. And the US instituted an interagency process, as well as a rapid response team to investigate allegations. So labor is a big focus of USMCA, trying to fix some of those issues from NAFTA. Again, USMCA was also intended to modernize in terms of environmental issues. Digital trade, which was very small and just beginning in the early 90s, is obviously a bigger part of trade today. So special provisions to address that. IP protections and all of those other aspects were incorporated into the agreement as well. And then included to increase sector-specific rules related to auto and steel as well. But it wasn't all provisions making it more difficult and harder. There were some facilitation changes to make the mechanics of trade a little easier. We'll talk about the certificate of origin in the next slide and de minimis, but also in the US, the NAFTA marking rules no longer apply. So if anyone had to deal with those were pretty confusing and onerous as well. With regard to the certificate of origin, under NAFTA, there was a set form that had to be executed by the exporter. Under USMCA, the form is gone. It's a free form certification that has minimum data elements that can be issued by the importer, exporter, or producer. So a little bit easier way to transmit data instead of a prescribed, paper form under USMCA. Again, these are minimum data requirements. Countries could add on to them over time. And the other major change that made it a little easier under USMCA was the increase of the de minimis threshold from 7% to 10%. And so this is an increase in the portion of non-originating materials that may not satisfy the tariff shift if they're 10% or less of the transaction value, which now excludes the cost of international shipment. If the non-originating goods are 10% or less and they don't satisfy that tariff shift, the goods can be otherwise qualifying. So it relaxes the de minimis threshold a little bit for minor components that may not meet that tariff shift. And just some provisions of NAFTA that remain unchanged that are often used. The duty-free entry for goods subject to repair and alterations, still permissible in USMCA. There's no merchandise processing fee on originating goods into the US. Accumulation is still valid, although it uses some of the language from TPP, again, kind of modernizing that. No customs penalties if a violation is subject to a disclosure by the parties and duties are paid. And there's no change to the duty deferral and drawback restrictions under NAFTA. Those are generally the same under USMCA. A lot of questions come up with regard to verifications and customs authorities and the country's ability to conduct verifications. They certainly can and they will. They will likely request information through a questionnaire or some other type of inquiry from the importer, exporter, or producer. They will generally reach out to the exporter or producer if they issued the certificate, and they can conduct a verification on site or virtually at the exporter or producer's location as well. And if the importer doesn't have the information required by the customs authority to validate the claim, the customs authority should be reaching out to the exporter or producer to gather that information before a claim is denied. So this will likely result in increased contact between customs authorities and producers or exporters, especially those who issue certifications that support a USMCA claim. And then one final note on the agreement itself. Under NAFTA, there was no expiration date. USMCA has an automatic sunset, which is 16 years after entry into force, currently June 30th of 2036. So unless parties agree, it will end on that date. There is a review process that starts at the 6th year of the agreement, and if the parties agree at that point to extend the agreement, it will extend for another 16-year term. If they don't agree, they will meet annually until the agreement either expires or an agreement is reached to extend it. So right now, the agreement is in place until 2036, and we'll have to see if any extensions occur beyond that. Right now, I wanted to walk through a few examples of the rules of origin under NAFTA and USMCA, and we'll start just kind of defining what the origin criteria, and these will often be referred to as criteria A, B, C, or D, and it refers to the way in which the product qualifies under the agreement. So under criterion A, these are goods that are wholly obtained or produced, but produced is a little misleading here, and entirely obtained or produced in the territory of one or more parties. And this refers to goods that are mined in the ground, grown in the ground, fished from the sea. These are like agricultural goods or mined goods. Certainly applicable, but generally only to specific industries. Criterion B is the most commonly used, and this refers to goods produced in the territories of one or more non-originating components that satisfies the rule of origin, either a tariff shift, an RVC, or both, and we'll walk through those. Criterion C relates to products produced in the territory entirely of originating goods. This occurs. It's much less common, but it is an option. And D is also relatively rare. It refers to specific goods that failed tariff shift for particular reasons and are able to satisfy the RVC, but very rarely used. So the NAFTA provisions were updated to the USMCA, in particular with the rules of origin. Some remain the same, some became easier, some became harder. It's really product and industry specific. So looking at a few examples here, these are snow skis under NAFTA and USMCA. The rule of origin is exactly the same. It requires a change to subheading 950611 through 950629 from any other chapter, and the chapter is the first two digits of the tariff code. And so in order for the snow skis to be originating, all of the non-originating components used to produce the skis must be classified outside of Chapter 95, and that's the tariff shift. The non-originating goods go from another chapter to the Chapter 950611 subheading for skis. The next is gum arabic, classified in 130120. This rule of origin changed, but it made it easier. So previously there was an exception for poppy straw. The new provision removes that exception and allows goods classified in the same subheading 130120 to qualify under USMCA. So it makes it easier to meet the rule of origin under USMCA. The next, nails of iron and steel, classified in heading 7313. This rule of origin basically remained the same, but only for the first 3 years of the agreement. After the first 3 years, you'll see listed in A, B, C there are other rules, alternative rules of origin, but they make it much more difficult for the nails of iron or steel to qualify under USMCA. So more difficult, but provided a 3-year transition to allow companies to be able to meet that higher requirement. Briefly on textile rules of origin, textiles and apparel products can be very difficult and complicated under any trade agreement, and that includes USMCA as well. Generally, there are 2 types of rules: a fiber forward rule and a yarn forward rule. It basically means that from the fiber forward, all of the materials must be originating, and that applies to fibers, yarns, and knit fabric. The yarn forward rule applies to woven fabric, apparel, and textile articles, and that just means from the yarn forward it must be originating. We'll talk very briefly about a summary of the changes to autos and motor vehicles. We're going to go into more details, so I'm not going to spend a lot of time on these slides, but basically there is a higher RVC requirement for the vehicles themselves. In addition to certain component parts of the vehicles, there's also layered on top of that a labor value content, which has a wage component where it must be at least $16 an hour. And there's a steel and aluminum content also layered on top of that. This applies to passenger vehicles, light trucks, but also applies to heavy trucks and other vehicles as well. We're going to focus on the rules for passenger vehicles and light trucks, but I wanted, because that is the bulk of the market, but there are also similar rules for heavy trucks and other vehicles. Passenger vehicles and light trucks are defined based on the tariff classification of the product in the agreement. Generally, passenger vehicles and light trucks are subject to their own RVC requirement that started at 66% upon entry into force and will increase over the first 3 years to 75%. Currently, we're in kind of the middle of year 2 at 69% is the regional value content. On July 1st of this year, it will go up to 72%. This is for the vehicle itself, and there may be alternative transition or phase-in periods that individual companies have negotiated with either of the countries. So keep in mind this generally applies to everyone, but there may be exceptions. And one thing to note is that the RVC requirement here is based on the net cost calculation. As we'll see, some other RVC requirements give you the option of a transaction value formulation. There are 2 different methods to measure the RVC, but at the vehicle level, it's only net cost. And again, there are certain components of those vehicles that have their own RVC, and these are listed in the tables of the auto annex. The first is core parts. These are major components of the vehicle. Again, engines, steering wheels, chassis, those types of major components are called core parts, and they're subject to an RVC that mirrors the vehicle RVC. So right now, again, 69% under net cost, but you'll also see there's the 79%, which is the transaction value RVC. Again, different methods to do the calculation, but similar result. Transaction value is always 10 points higher because the values in those are often higher. The next category is core parts and then principal parts. These are found in Table B of the Auto Annex. I included a few of them here, but these are important parts, but not quite as important as core. Ball bearings, fuel, fans, pumps, those types of products, principal parts, subject to their own RVC level, slightly lower than the vehicles, currently at 65%, eventually increasing up to 70%. And then the third category is complementary parts, and these are found in Table C. These have, again, even a slightly lower, currently at 63% under net cost, increasing to 75% after three years of entry into force. So core, principal, complementary, all parts that are identified and have to meet this regional value content specified in the auto annex, in addition to the auto specific or product specific rule of origin. Now, for passenger vehicles and light trucks, the parts that are found in tables B and C, that's the principal and complementary parts. Those goods, if they meet the tariff shift at the product specific rule of origin, automatically meet the RVC requirement, or they don't have to meet the RVC requirement found in tables B and C. So important to keep in mind which method you're using to qualify the goods under the product specific rule, as it may impact whether they meet the RVC under tables B and C as well. And finally, for the core parts, there's table A2, and this is an additional requirement that passenger vehicles or light trucks can only be originating if all of the parts under column 1, engine, transmission, body, and chassis, are originating. And there's different ways to calculate that, whether it's based on the super core, which are all of the core 1 parts together, or using the column 2 components. But this makes it harder to qualify vehicles under the USMCA. In addition, there is a dispute between the parties, the US, Mexico, and Canada, particularly Mexico and Canada versus the US, in terms of the interpretation of how this is done, whether the originating goods roll up to 100% originating value in this analysis, or whether you basically conduct the RVC all over again. That is currently the subject of a dispute settlement panel between the parties, and we would expect a decision in that by September-ish of this year. So this may be changing depending on the outcome of that panel, but right now, there are differences in interpretation of the agreement with this and a few other issues with regard to the agreement. So in addition to the RVC requirements, there is also a requirement that 70% of the steel and aluminum be originating. This is importantly limited to only certain enumerated steel and aluminum articles that are listed in Table S of the Uniform Regulations, and only applies to the direct purchases from producers of the vehicles, or the contracts that they negotiate on behalf of their suppliers, but it also applies to certain stampings that form the body and white chassis, regardless of who purchases that steel. So an important piece to keep in mind. And then the final issue for automotive components in particular is this new labor value content requirement. And this was in place this is in place for passenger vehicles, light trucks, and heavy trucks, and adds another layer to the qualification. So in order for the passenger vehicle to qualify, It must meet the labor value content, and there's different items that can satisfy that. It started at 30% upon entry into force and will increase over time to 40% for passenger vehicles only. Light trucks and heavy trucks are subject to a 45% labor value content from initiation with no phase-in. So this slide just provides a basic overview of all those different layers of qualification requirements for automotive goods. You've got the labor value content that we just spoke about, regional value content for the vehicles themselves, the core parts, as well as the principal and complementary parts, and then the steel and aluminum content. All of those together must be satisfied in order for the vehicle to meet the originating requirements under USMCA. So these requirements place large burdens on vehicle producers and the auto suppliers in order to meet the requirements. So from a vehicle producer's perspective, they're really looking to scrutinize their supply chain and processes to make sure that they can maximize the qualification criteria, whether that's the RVC requirements for the vehicles, the labor value content, or the steel and aluminum content. All of those are really critically important to the vehicle producers, especially as the phase-ins kind of ratchet up through the next few years. And this is placing increased pressure for the vehicle producers to request information and survey their suppliers for this new information, whether that's originating criteria, originating content, whether the de minimis value threshold is used, qualified goods. All of those are increasing information requests that weren't really obtained under NAFTA because they weren't really necessary, but now because of the added requirements are really becoming more important for suppliers throughout the supply chain. And suppliers are really getting bombarded from their customer, whether it's the vehicle supplier or a tier one supplier, because everyone's the pressure to get this information is flowing, down through the supply chain. And so it's important, if you're getting requests for information or qualification data criteria, to really undertake a due diligence and to obtain the information. This will likely involve education and training to understand how goods qualify, how your goods qualify, what rules of origin and other requirements may be applicable to your goods, so that you can accurately respond to any requests from your customers or their customers. And there is, because of the increased information and importance of this information, there is some liability for providing incorrect or inaccurate or information that can't be supported by records and information in your organization. And this can be anything from a business dispute that results in a monetary penalty to a loss of sales, or even potentially penalties from a customs authority, depending on your role in the supply chain. So, as I close here, I just want to stress how important it is to engage in the practice of compliance, to take those practices you may have had under NAFTA, or maybe you didn't have any because the information wasn't necessary under NAFTA, but to incorporate practices where you can support any data or information that you're reporting to customers with regard to USMCA origin, especially if it relates to labor. Those might be policies and practices that were not in place under NAFTA, but are more important now. And it's important to maintain detailed and accurate records to support any claims in the future. So thank you very much. That's the close of my prepared slides, and I'll turn it over to Thomas to see if we have any questions.
Okay. Yes, thank you, Mark, for your excellent and concise presentation. I think although USMCA is a very complex topic, you helped us understanding the legal and technical implications of implementations and the new regulations a little bit more in detail. Yeah, in the meantime, Mark, we registered some participants' reactions. I would suggest that we go straight into the interactive part where I will read out the questions and the comments out loud to you, and I will ask you to address them. The first question we have here is actually a question which we get a lot here in Mexico regarding the steel and aluminum content. It goes like this: does the 70% steel and aluminum content requirement also apply to part suppliers? What's your opinion on this?
Right. So generally no. The steel and aluminum content is a requirement for the vehicle producers themselves for steel and aluminum that they purchase. It could apply to part suppliers if the vehicle producer secures or negotiates the contract on behalf of the part supplier, or if the part supplier is producing some of those stamped parts that form the body in white or chassis. Sometimes it'll apply to those products, but generally it's only a requirement for the vehicle producer itself. But that's a good question that we often get as well.
Thank you a lot. A question we get a lot here in Mexico also is about penalties. Many companies ask us like, what are the penalties if the USMCA standards or requirements are not met? Do you know which is the competent authority and what are the penalties here, and who at the end can be held responsible for not meeting the USMCA standards?
Sure, that's a good question, and it's one that often occurs. So generally, the importer who makes the claim, it has primary responsibility for substantiating and meeting that claim. They can rely on information provided by producer or exporter, but generally it's the importer who will be subject to the penalties. There are rare instances in which producers or exporters could be penalized, but I would expect those would be relatively rare.
Okay. We were also asked about the presentation itself. Yes, the presentation will distribute it, yes, with Mark, with your permission at the end of this webinar, or within the next hours or day, we will distribute all the presentation and contact details to all registered parties. That means not only the persons being present here today, but also the persons signing up for this webinar will have access to these presentations. Mark, there's one more question regarding the following. It says that the September date mentioned for the current roll-up dispute is based on the deadline to define the sentence, ? Where could this determination be reviewed?
Yeah, so the dispute settlement panel is currently reviewing the issue. We would expect, based on the timeline, that they would issue a decision around September. There is an appeal process, which is probably likely that will occur. While we'll have an initial read in September, it likely won't be resolved for another 6 months or year after that. Yeah, so stay tuned. Okay. The next question is regarding the LVC. This is also a question which we get a lot here in Mexico. How can a tier supplier who is producing 100% of its parts in Mexico comply with the LVC 40% at least $16 per hour? Yeah, so the labor value content can be difficult. There are specific rules and ways to calculate the labor value content percentage. Who gets included, who doesn't get included. You know, executive staff generally is not included. It's focused on those, you know, hourly or production workers. And so it will depend on the information that's available in the company and whether you can support the $16 minimum wage. I hope that answers the question.
Thanks. Yes, certainly. And if not, I obviously invite all the participants to send us your questions, and we will do our best to tackle those issues. If we haven't answered all your questions within the webinar, you will obviously have the chance to contact us after this webinar, like you already know, I guess. Mark, there's one more question regarding RVC requirements. What about the aftermarket and the service or service parts? Do the higher RVC requirements for auto products listed apply as well to this aftermarket?
That's a good question. Generally, no. Aftermarket or service parts only have to meet the product-specific rule of origin requirement. Those additional RVCs in tables B and C only apply to original equipment that is used by vehicle manufacturers. Yeah.
Okay, very good. And I would like to raise one question, which is often, which you often heard already, but maybe you can tackle this because it might be of interest for our audience today. Where can companies or entrepreneurs actually read up the requirements for their customs tariffs? I mean, you already tackled this a little bit in the middle of your presentation, but where can you actually read in detail about the requirements in place?
Sure. So the best place to find the detailed requirements for your particular products are going to be the tariff schedules from each of the countries. The tariff schedules will include not only the ordinary tariff rate, but whether it is subject to the USMCA and what that rule of origin is, whether it's tariff shift, RVC, or combination of both. And those are all available online.
Okay, perfect. Let me browse quickly through the questions. I mean, you guys all have the opportunity to raise your questions now. Even though we're coming towards the end of this webinar, I think we still have a couple of minutes left. At the moment, I have one more question posted in German. I will just browse through it quickly to translate it then. It is about copper and the local content. Okay, yeah, this is a bilateral question regarding an inquiry we received in the past. I think we will address this question after this webinar and trilaterally in this case with you, Mark, if you allow me to do so.
Of course, sure. One other thing, Thomas, that I often get asked is it relates to the China Section 301 tariffs and how that could impact USMCA and some of those issues. And currently, it is possible for a good to be duty-free under USMCA and meet the USMCA rule of origin, but be subject to China Section 301 tariffs because the rule of origin under USMCA is based on the specific rule agreed to by the parties, but the China tariffs are based on a different rule of origin, which is called a substantial transformation. And so there could be instances where a good would be duty-free and Mexico origin, let's say, for USMCA purposes, but still be subject to a 25% tariff because of the components that are used to produce the product in Mexico are Chinese origin and don't undergo a substantial transformation. In the U.S., U.S. Customs has proposed a rule that would avoid this, but it currently hasn't been finalized. So again, that's another issue to stay tuned about, because that may be changing how customs deals with that in the U.S.
Okay. In the meanwhile, I'd like to go back to your to the slide where you mentioned the A, B, C, D categories of the regional value content. Let's get back to the topic of copper. What if there is a good, for example, copper, which cannot be sourced locally? Do the RVC apply in this case as well, or do we count with exceptions?
So the copper isn't found in the U.S., Canada, or Mexico?
In Mexico in this case, but how about the zone, like North America in general, and about Mexico? And so let's assume it's not available in North America.
Okay. Yeah, there are certain provisions for products that are not available or in short supply. I'd have to look and see whether it applies to copper products. I would doubt it, because there is a copper industry in the U.S. I know in particular, but I would have to check. I'm not exactly sure how that applies to copper.
Okay. The person raising the question is emphasizing that in his case, it's definitely not available within the region, and the product or the copper is actually coming from Germany in this case, and would account for more than 70% of the total value of the finished good.
Okay.
So that's probably something we would have to check, but we would get back to this, because this is technically very specific, I think.
Yeah, definitely, and it could be one of those exceptions we could look at. Yep.
Okay, so that means that products which cannot be sourced locally, there are some exceptions addressing this issue.
Some negotiated exceptions for products that are clearly identified as not available in region. Yep.
But with all goods and products, it would be subject to check the customs tariff and see what rule actually applies.
Exactly. Yeah. Yeah, it'll be very specific to the particular product at issue. Yeah.
Very good. I don't see any more questions here, so it might be that there aren't any more questions here. Yes, I think that just double checked it. So for now, I think we came to the end of this session. Once again, I'd like to emphasize that obviously you will have the opportunity to ask us or Mark regarding your specific questions. We will be very happy to tackle your concerns. And yes, Mark, once again, I would like to thank you for being today's protagonist, today's speaker. I would firstly like to thank you for your time and your presence, and also for being our trusted partner in USMCA questions, and also being part of our big events we used to have throughout the US and the North American region. Talking of events, I would on this slide like to I would like to point out some of the major events we're hosting this year. So we have 3 events which are like our prime events, I would like to say. The first is relevant to all our Austrian participants here. It's the Exportes Day, which is the biggest internationalization event in Austria. It's taking once again place in presence, let's hope. And the target group are all export-oriented companies in Austria. I think this is a very already known event in Austria, and I'm very happy to announce that this is a presence event where you can come and meet the commercial counselors from all around the world on June 28th in Vienna. The second event I'd like to mention is something we're very proud of. Mexico is hosting its first Austria Connect event. This is our flagship event for Austrian subsidiaries and business partners in Mexico, as well as Austrian managers with business interest in Mexico. The main topic of our conference will be nearshoring, and I would like to invite you all for September 29th to join us here in Mexico City. And a bigger Austria Connect edition is taking place on the preliminary date of 8th and 9th of December. This is the Austria Connect North America, summing up the region, meaning that we would like to invite all Austrian subsidiaries and companies active in the US, Canadian, and Mexican market to join us. This conference was unfortunately postponed due to COVID from last year, December, to this year. And yes, we're looking forward to meet you guys all in presence, because there was a lot of webinars and online sessions in the past, and we're hungry for in-person events already. Yes, I would now like to close this session. Thank you all for your attention. Once again, Mark, I would like to thank you for your excellent presentation. And lastly, I would like to also thank our offices in New York and Toronto for your strong support. Yes, once again, if you haven't took the chance to raise your questions, feel free to reach out through these email addresses. These are New York at advantageaustria.org, Mexico at, and Toronto at. Also available for Austrian participants with the addresses New York at wko.at, likewise Mexico at and Toronto at wko.at. That's all for today. Once again, I'm wishing you all the best from Mexico, and stay healthy. See you soon, and hopefully see you soon in person. Take care and have a lovely day or evening, depending on from where you're listening to us.